Arkansas, June 2025. The same day a widow loses $1.4 million on appeal in a trust dispute, she learns the result from a companion case, the legal malpractice appeal against the trustee, one that determines whether she keeps anything at all. For years, her late husband trusted the same lawyer for everything: the premarital agreement, her husband's estate plan, the trust that now controlled her financial future. The trustee wasn't just her husband's lawyer. At times, he was her lawyer too. But when trust disputes erupted, when she found herself fighting for financial independence, she realized something. The trustee's named partner had been wearing too many hats: family lawyer, estate planner, trustee, executor, her husband's lawyer, her lawyer. And some of those roles conflicted. So she sued for legal malpractice, professional negligence, conflict of interest, breach of fiduciary duty. On the eve of mediation, they settled the legal malpractice lawsuit for $2 million in March of 2023. But it wasn't over, because her lawyer received from Trustee a writ of garnishment. Trustee and his law firm trying to garnish the settlement from their own alleged legal malpractice, wearing too many hats in too many cases. The trustee, the same law firm she just sued for legal malpractice, was attempting to seize most of her settlement money that its insurance carrier paid to satisfy the $1.4 million judgment from the trust case. But there's more. The trustee wasn't just trying to intercept the money, it filed a motion to intervene in the malpractice case itself after settlement, after payment of $2 million. Trustee wanted another seat at the table, not just as defendant, but also as a third-party trustee, to claim the remaining settlement proceeds, to contest widow's second attorney's fees, turning a settled legal malpractice case into one more appellate battlefield. Now, in part 2 of the Lasiter case, we examine whether you can lose a malpractice settlement payment to the law firm who allegedly committed the malpractice, and what happens when your former lawyer, now serving as trustee, becomes your legal adversary.
When fortunes collide with courtrooms, wealth managers, financial advisors, accountants, fiduciaries, and lawyers need real answers. Welcome to Wealth Litigated, where Professor Kelly Lease Murray, J.D., lawyer, legal scholar, and retired Vanderbilt Law faculty, analyzes actual courtroom wins and losses in asset protection to deliver actionable insights that optimize your client's wealth outcomes. From explosive family feuds over fortunes to sophisticated financial fraud, each week we explore what worked to protect wealth and what exactly went wrong, so you get it right. And now, here's your host, Professor Kelly Lease Murray.
This is episode 104 of Wealth Litigated, The Malpractice Trap, Trustee's $2 million clawback attempt, part 2 of 2, the Lasiter Trust Dispute, ending a 9-year legal battle with significant losses for everyone, including the lawyers. I'm Kelly Lease Murray, and this is Wealth Litigated, delivering all the drama of true crime without the blood. We don't just tell you what actually happened in court. We also show you why it matters to your professional practice and how it impacts your client's wealth outcomes. Let's gavel in. The Malpractice Trap, Trustee's $2 million clawback attempt. How Trustee tried to garnish the $2 million settlement with widow from its own alleged legal malpractice as her lawyer. Alive. So the math here, on the one hand, supports the themes of the courts and the trustee, that this is a case of generosity versus greed. The husband's generosity in his estate planning to award the wife annually more than the prenuptial agreement obligated him to. That's undisputed. So why did the wife even challenge this? It may not just be greed. I mean, it depends on your perspective. If for anyone after divorce or after the death of a spouse, reduction in lifestyle is not uncommon. And here, the wife is a beneficiary of trust funded solely by $15 million in life insurance. She, her 2 minor children, his now 2 adult children from a previous marriage, and his 2 sisters were the original beneficiaries. But the wife was not entitled to any of his separate assets, but presumably those blood relatives were sharing in his separate assets, high net worth companies, and the appreciation during the marriage. All of that was segregated under the premarital agreement. So, presumably, there's plenty for the blood relatives to inherit. But the wife and her interests, before she was deemed to have violated the no contest provision, was limited to this $15 million. On the right hand side of this slide, we're looking at what the wife demanded. One of her demands was $15 million outright, not controlled by the trust or this trustee. There's reference in the appellate briefs that the wife, perhaps at a deposition, there's a citation to the record, but that the wife admitted if the trustee had no longer been the trustee, this is the husband's 16-year lawyer, his trusted lawyer, the only named partner of the trustee's law firm, that if trustee had not been the trustee, that the remainder of her claims could have been settled, which is truly a shame for her and everyone else involved, but really that was the crux of it, to remove him, because one of the arguments that she and her lawyers made on appeal was easily refuted by the trustee and his lawyers and accepted by the appellate court, that in Arkansas, a lawyer is eligible to serve as a trustee. There are plenty of quasi-legal roles that just having an active law license makes you eligible for. So it's not surprising that even though the trustee in his one-stop shop wasn't registered as a trustee, that the trustee himself was eligible because he was a lawyer and an accountant. So the wife, when she demanded $15 million outright, that is nowhere in the trust provisions. The trust never awards her $15 million of anything. And when she demanded it and then litigated for it, when she litigated for that, that was a trust contest. That was challenging the terms of the trust that put her income, controlled it with trusts where she had the income out of those assets, but she didn't control the principal of those assets. So why? Why did the husband, as he spent the remaining 9 months of his life significantly revising his estate planning, why did he make these provisions? Why did he set things up with the trustee who presumably wrote these estate plans, the two trusts and the pour over will? Why does it look like traps were set for the wife to fall into? Because she certainly did. Hypothetically speaking, it's like someone who knew her really well predicted her behavior, if giving her notice that you can't contest the trust because that has no contest provisions. Why? On the husband's side, why did he choose to set these conditions that bristled with the wife? Why did the wife disregard 3 different lawyers giving her opinions that she risked being disinherited, not just prospectively, but clawing back 1.4 million of what she'd already received by trying to pursue some of the claims? In the middle of the opinion, the appellate court gives us the husband's why. It's very dramatic, which is why we've reserved it till now in the Lasiter case. We've talked about the obvious themes, and these are the themes of the trial court's opinion, of the Arkansas Intermediate Appellate Court's opinion, and of course the briefs from the trustee and his lawyers, generosity versus greed. But another way to look at this from the wife's side is control versus independence. When she demanded $15 million outright, outside control of the trust was so that she did not have to get the permission of this trustee, her former lawyer, her husband's main lawyer, but at times her lawyer, who she's suing for legal malpractice, so that she wouldn't have to ask his permission for additional disbursements under the trust, for example. That's seeking independence, which is also a theme, it's just not the winning theme. For the husband, his why is summarized in the middle of the appellate opinion that came down in June of 2025. The appellate court writes that the husband engaged in substantial estate planning after his cancer diagnosis in 2015. According to the trustee, the husband was concerned about wife's extravagant spending. Now we see some of the husband's why. And of course, the trustee had the inside track. He was the lawyer for the husband as these revisions to the estate planning was done. Unlike an independent third-party trustee who, a corporate trustee who was not involved in any of the estate planning, who would have none of the backstory, this trustee, the named partner of the trustee law firm, the husband's trusted lawyer, knew all the backstory, all the subjective intent that wasn't written into the estate planning. According to the trustee, husband was concerned about wife's extravagant spending, ensuring that all of his children were provided for, and believed he needed a strong estate plan to manage these difficult family dynamics. This is another clue. Wife's second marriage, husband's third marriage. At the time they were married, he was in his late 30s, she was in her early 30s, about a 6-year age difference. The husband already had 2 children who, at the time of the marriage, presumably were not adults. At the time of his death, his 2 oldest children are adults. But his children with the widow are still minors at the time of his death. The difficult family dynamics sounds like it's coming from the blended family situation. So we have a high asset husband, a high asset lifestyle where the wife's spending, the husband in his estate planning viewed as extravagant, and then what the husband's trustee describes as difficult family dynamics. There's also a reference in the appellate briefs to drama, family drama surrounding the husband's illness at his deathbed, which supports the generosity versus greed theme, which was ultimately the prevailing theme in this case. The trustee said that the husband's estate plan was at least partially designed to keep the wife's spending in check. And that's how we know that some of these provisions intentionally reduced her income, intentionally reduced the cash flow that she had access to on a monthly basis lower than what she enjoyed when they were married. Well, during this high asset marriage, meaning the husband was a high asset individual, high asset separate property, and husband's overall intent was that his 4 children and the wife have a secure financial future. Husband, however, according to the trustee, was concerned about the wife challenging the provisions regarding the management of assets and distributions to her. Now remember, this is less than she had enjoyed during the marriage while the husband's alive, specifically included these no contest provisions. So what do you think? Why was the trust set up like this? Why was her cash flow reduced below what she enjoyed during the marriage? Were the 4 children really at risk of running out of money? That's highly unlikely. We don't know. I'm in hypothetical territory now. We don't know for sure because it wasn't part of the appeal. But those separate assets that the premarital agreement kept separate, including the appreciation during the marriage, presumably his blood relatives were inheriting all of that, or at least a large portion. There were some charitable bequests. The wife was only a beneficiary to a portion of the $15 million in life insurance proceeds. And by the way, what does that cost? What do the annual premiums to maintain $15 million in life insurance? That was a substantial investment on the husband's part, and given his untimely death at the age of 50 from cancer, he was able to fund the irrevocable insurance trust solely with this new asset, $15 million in life insurance proceeds. So who's inheriting the separate businesses and the income from those businesses? Presumably his 4 children, his 2 sisters, and other relatives. The worry that the 2 minor children might not be taken care of is not realistic because of all the relatives, the only 2 who had a legal claim against the estate to be supported, all other things considered, are the 2 minor children. The husband's estate has plenty to support them, and the children have a legal expectation to be supported given the significant assets available in their father's estate planning. So some of those arguments just don't hold factual water. But this is the why. And it also starts to suggest the wife's reaction because during the husband's illness, while he has lawyered up with the trustee, his one-stop shop named partner, she lawyers up. And she's criticized for it in the trustee's appellate briefs that during the husband's illness, she has a number of lawyers and financial advisors. We know she got 3 legal opinions concerning her ability to challenge this estate planning, cautioning her against directly challenging trust provisions. What's the wife's why? I've already hinted at it. This control, but also another kicker that probably contributed to her aggressive disregard of the legal advice regarding the no contest provisions is the secrecy. The distribution directives that this trustee had absolute discretion over. He was not allowed to tell any of the beneficiaries what the distribution directives themselves were. So all they knew was the actions that he could share with them, a payment based on X. The wife uncovers the secret distribution directives through her trust contest, by challenging the terms, by not threading the needle with the curveball. For example, at the end of part 1, we talked about the pilot's license. Was that void ab initio? Was that never going to happen? Because at the time the irrevocable insurance trust was created, he was already ill with cancer and might have been undergoing aggressive cancer treatment, which may have invalidated his airman's medical certificate. So if that $2 million trust, additional trust, which its intention was to help raise the wife closer back to the standard of living she enjoyed while the husband was alive, it was taken away when the trustee opined that the condition wasn't met, and therefore that $2 million would not be put into a trust for the wife's benefit. This is a quote from one of the legal opinions that the wife did not follow. And this law firm actually ended up representing her, notwithstanding their original recommendation that she not challenge the trust. Husband's faith and trust in the trustee, which I understand is concerning to you for many reasons, not the least of which is you do not know the distribution directives, coupled with the fact you may never have access to the distribution directives, and that the no contest could well result in you being disinherited. As such, I strongly urge you to be cautious in your approach to trustee and any dealings with the trustee. The no contest contests. At least 4, this is what the Arkansas Appellate Court held. The wife violated the no contest provision in at least 4 of her claims. So the claims that weren't trust contests was her attempt to remove the trustee. And that makes sense. If the trustee is terrible, losing money, wasting money, embezzling money, none of those facts apply to this case. But there's plenty of misconduct that would warrant removal of a trustee. And a no contest provision should not protect a trustee who either isn't qualified or should be removed for bad acts. And then the trustee legal malpractice action, also not a trust contest. It's part of the tragic result of this case. The first litigation filed by the wife and her lawyers was the legal malpractice action. That's the one she wins. And we're going to be talking about that in detail in this part 2. She is the prevailing party in the trustee legal malpractice action because the settlement is for the policy limit. The maximum available from the trustee and his law firm's legal malpractice insurance carrier was $2 million. That's what it settles for. That is a severe event. That is not some run-of-the-mill legal malpractice settlement. Those are between $100,000 and $300,000. $2 million the policy limit, that was based on significant analysis by the legal insurance carrier itself. And the legal malpractice action, it was the first case filed, but it's called Lasiter 2. It's all very confusing because the lawyer for the husband, who then becomes the trustee, and his law firm are wearing so many different hats, it gets confusing which hat they're wearing in which of these lawsuits. But those are the 2 that were not trust contests. Now, the first one on this slide, the pilot's license condition, what I call the curveball, the wife and her lawyers could have threaded the needle, probably, by challenging merely the trustee's interpretation of the plain written language. Based on what we discussed in part 1 of the Lasiter case, the plain language actually benefited the wife. It's when it's ambiguous that we bring in the FAA and the Code of Federal Regulations, where the FAA requires 2 things to actually pilot an aircraft legally: the airman's certificate, which is the pilot's license, can you fly a plane part, and then the airman's medical certificate, are you healthy enough to not endanger yourself and others? That needle should have been threaded. It was not. We talked about how that alone was contesting the terms of the trust, which is a direct violation of the no contest clauses in the 2 trusts and the pour over will, because the wife demanded $15 million outright. She demanded $2 million outside of trust control. Well, that pilot's license provision never awarded her money, the principal. It directed the trustee to set up a trust, fund it with $2 million out of the $15 million in life insurance proceeds to help raise the wife closer to the lifestyle she was losing. Additional trust contests, according to the Arkansas Court of Appeals, electing to take against the husband's will and seeking to invalidate the premarital agreement. This needs some discussion. The wife's lawyers argued on appeal that the premarital agreement was a separate contract. It's not a trust document. And why, if she challenges it, how is that a trust contest? Because the husband included in his estate planning documents, he incorporated expressly the premarital agreement that it remained in full force and effect. This was included in the revocable trust that was revised in February of 2016, just a few months before the husband died. And because the premarital agreement under its own terms could not be modified without written assent of husband and wife, with the husband's estate planning reaffirming that the premarital agreement remains in full force and effect, the husband and the trustee who helped write this made the premarital agreement a condition of complying with the trust. So yes, the wife can challenge the premarital agreement, and she is simultaneously violating the no contest provision and being disinherited. So if she had only done that, if she had only sought to invalidate the premarital agreement and done nothing else, she still would have been disinherited. She was free to make that choice, and it did cost her a lot more. So the cost benefit analysis is definitely in the negative on that decision. And also, the grounds to invalidate the premarital agreement, with the premarital agreement being enforced in this trust litigation, she can't take against the will, and she was unsuccessful trying to invalidate the premarital agreement. And then her claims against the estate outright, demanding $2 million outright, demanding $15 million outright. Nowhere in the trust does it ever give her that kind of money. When she demanded that in litigation, that was a trust contest. Those are the 4 trust contests specified by the Arkansas Appellate Court in June of 2025. And this is important for everyone, for estate planners, for lawyers, for wealth managers. It's important not just to get the legal opinion of against legal advice. You're risking being disinherited. The trustee could claw back what you've already been paid. Not just that, but the against financial advice, showing what happens, how much is this worth to remain a beneficiary over 10 years, over 20 years? Is there a disinheritance upon remarriage? If there isn't, combining the against legal advice with the against financial advice, maybe one, the other, or both would help convince a surviving spouse not to risk violating the no contest clause, because it's so draconian. Even the Arkansas Court of Appeals opinion affirming the $1.4 million judgment against the wife, clawing back almost half of what she'd received in the first year because she is disinherited by violating the no contest provisions. One of the judges wrote a concurrence worrying about the clawback, about years of a beneficiary receiving income under a trust, spending it, no longer having it, and then at some point filing a trust contest, ill-advisedly maybe, and the trustee tries to claw back money that has been dispersed over 10 years. That was the caution, but that judge still concurred in the result. On appeal, the wife and her lawyers argued that the trial judge abused its discretion concerning the Q-tip eligible trust. The gist of the wife's argument is this: the trust provisions were very specific that the husband intended for a portion of his estate to be shielded from estate tax for the remainder of the wife's life. And that's what the Q-tip election is about. So a $5 million be put into a trust. The trustee had the discretion to elect the Q-tip treatment so long as he made that election in the estate tax return. And the trustee did all of those things on time. More than 3 years passed, so now the IRS's statute of limitations has expired. Even if the trustee messed up or a beneficiary somehow interfered with Q-tip eligibility of that trust, there's nothing the IRS can do about it, which is what the trustee argued on appeal. But the wife's lawyers looked at this marital deduction trust share, This is what funded, it was $5 million out of the $15 million life insurance proceeds. And the wife was eligible to receive $5,000 a month. And then every year on the anniversary of the husband's death, a bonus of $25,000, which to this high asset marriage and lifestyle is not the bonus she would consider a bonus, put it that way. But did the enforcement of the no contest provision, did it invalidate the Q-tip election? That's the issue that the wives and her lawyers try to make on appeal. The problem for them is this abuse of discretion. At the trial level, they had a much better chance of being successful. Even if the appellate court agreed with them, sidebar, it didn't. The appellate court did not agree with the wife and her lawyers on this Q-tip issue. But even if it had, abuse of discretion is really difficult. They had a much better chance at the trial level with the issue presented. Once it goes up on appeal and the only way to overturn it is abuse of discretion, the trial court absolutely did not abuse its discretion. But here's how that played out on appeal. The trust share creation requirement was for a portion to be eligible for Q-tip election, for the trustee to have discretion, but the husband's intent was clear that he wanted this $5 million to be protected from tax on his estate, giving his surviving spouse, if she survived him, $5,000 a month and $25,000 bonus annually. The wife argued about abuse of discretion because the Q-tip provisions talk about any provision that interferes with the Q-tip election shall be void and without effect. So the wife and her lawyer zoomed in, and that looks really compelling until you see what the appellate court did. The appellate court actually put into its opinion, we zoom out. And by zooming out, the appellate court analyzed the language that whoever violates a no contest provision, challenges the trust directives, is disinherited and is deemed legally to have predeceased the husband and is deemed to have had no heirs, no heirs at the time they predeceased the husband. Well, if the wife actually predeceased the husband, there is no Q-tip election. Her death would have defeated the Q-tip election. And that's why the appellate court held that the trial court did not abuse its discretion and actually held whatever the Q-tip election's fate may be, it has no bearing on the no contest clause's enforceability. This is an important holding. The appellate court does not decide the issue of whether the trustee, by enforcing the no contest provision, defeats the Q-tip election and has increased the taxation of the husband's estate. The trustee is saying, well, statute of limitations expired. And oh, by the way, substantively, it doesn't do that either. But the main defense there is the statute of limitations has expired. The IRS cannot come after anybody on this issue. But the appellate court concludes the wife took that risk. She had all the information she needed. And the court wrote this. There's some snark here. While we can appreciate wife's purported concern about the estate tax consequences that her forfeiture may have caused, we would be remiss if we were to ignore the fact that it was she who contested the husband's estate plan and testamentary wishes, and thereby accepted the risk of forfeiture and any consequences. So that's how the Q-tip issue is resolved against the wife. But mainly on appeal, she had almost no chance because of that abuse of discretion standard. Which brings us to Lasiter 2. This is the legal malpractice action. This was the first litigation the wife and her lawyers filed. This was not a trust contest. This lawsuit did not disinherit the wife, and the appellate court affirmed that. She was not disinherited because she sued the trustee, his law firm, another lawyer in his law firm for legal malpractice. She actually is the prevailing party in the sense of a significant settlement. Now, settlement means the trustee, the other lawyer individually, and the law firm do not admit liability. But when your insurance carrier pays the policy limits, and the policy limits are $2 million, a severe event, there's a there. The legal malpractice claims included professional and ordinary negligence. For me, the one that stands out the most is the conflict of interest, breach of fiduciary duty, breach of the trust agreements. This matters, and this shows us why, without admitting liability, that his insurance carrier paid the policy limits to settle this legal malpractice case. And it settles in March of 2023, right after the trial court rules against the wife and holds that the wife violated the no contest provisions, is now disinherited, and that the trustee must claw back $1.4 million of the original $3 million. So she loses that at the trial level. She appeals. Right after she loses at the trial level, the legal malpractice action settles. In the legal malpractice action, she has two sets of lawyers. The first lawyer's legal fees are almost $700,000, and those are deducted from the $2 million. Now we have approximately $1.3 million left. She has another lawyer, another law firm. This is a law firm in Arkansas that was founded in 1820. One of the three that advised her not to challenge the trust, who represented her in what was deemed a trust challenge litigation, both at the trial level and on appeal. They're owed a 20% contingency fee, which would be another $400,000. So out of the $2 million in the legal malpractice settlement, the wife is netting over $900,000. And she's also paying her legal fees. The legal malpractice litigation really focuses on the trustee wearing too many hats in too many phases of representing husband, representing wife, representing husband and wife, and then becoming adverse to her as the trustee. Right after the $1.4 million judgment is rendered against the wife, judgment interest starts accruing at 2.5% per annum. This amount, by the time the appeal is completed in June of 2025, she now owes $1.6 million. There's another judgment for $168,000, and that interest is 4.5% per annum. Lasiter 2 settlement. Remember, this is the legal malpractice litigation that was filed first, but it's called Lasiter 2 because of the order of resolution. The trial court resolved Lasiter 1 first, and then when the wife lost her trust challenge and became disinherited, that's when Lasiter 2, the legal malpractice action, settled for the policy limits, a severe event. When lawyers are sued for legal malpractice, their professional liability insurance premiums can go up. When your insurance carrier settles a claim against you for $2 million, your insurance premium is probably going up by a lot. Additionally, one of the top 4 practice areas that are sued the most for legal malpractice, trusts and estate planning, which is the garnishment was denied. The trustee files a motion to intervene. Now, this involves Arkansas Rule of Civil Procedure 24A2. There are requirements to be able to intervene in a lawsuit where they're not a party. Strangely, the person who is the trustee, the person who is the individual legal malpractice defendant, along with his law firm, along with another lawyer from his law firm, he's just changing hats. He already is involved in Lasiter 2 as a defendant, so he doesn't need to intervene, and he has no right to garnish or attach to do anything with those proceeds except pay them to the wife and her lawyers. But as the third-party trustee from Lasiter 1, he's trying to intervene. He's just changing hats and trying to be a third-party intervenor under this rule of civil procedure. What's at issue is the $400,000. The trustee is trying to get the remainder of his own legal malpractice settlement money that he agreed would be paid to the wife to resolve her legal malpractice claims against him, his law firm, and another lawyer in his law firm. He's trying to get the remainder, that $1.3 million. Remember, the trust is owed $1.4 million before her second lawyers deduct $400,000 because they have a contingency arrangement. Sidebar: how much does this kind of litigation cost? Well, we know in just Lasiter 2, which was much smaller than Lasiter 1 in terms of legal work, in just Lasiter 2, the first lawyer, his legal fees are almost $700,000. Her second law firm's contingency fee, 20% contingency fee in Lasiter 2, 20% of $2 million is $400,000, leaving the wife with over $900,000 out of $2 million. That's her net out of the $2 million. But it begs the question that when lawyers advise a client not to contest a trust, not to risk being disinherited under no contest provisions, and then represent that client with a contingency fee, isn't that encouraging the client, making it more affordable for the client to technically Well, she's acting against legal advice to begin with, but to be acting against her own interest. If she had had to pay these legal fees ongoing, that's a totally different scenario because in Lasiter 1, the wife loses. So if this $400,000 fee owed to the second law firm, they represented her in Lasiter 1. If that was also contingency fee, they got zero. They spent over 9 years representing her, and in Lasiter 1, if it was a contingency fee, they're getting $0. So the only money the second law firm is getting is from Lasiter 2, their 20% contingency fee in the legal malpractice action. $400,000 to pay for all they've done for 9 years in 2 cases, not just one. So that's what this costs. It costs less because it was contingent, 20%. It would have cost more to be billed over the course of 9 years. And perhaps that's a method to help dissuade a client from acting against legal advice, acting against their own financial future interests. And another point I want to raise is for a client who wants to fight. This happens in divorce. This is why mediation is so helpful, where everybody has a voice. Everyone gets to say what they feel is needed to be said. Sometimes they don't say it to the other spouse, sometimes they just say it to the mediator, but they get to be heard. That is significant. The wife could have been heard with just Lasiter 2. Lasiter 2 has a significant consequence to the trustee personally. He pays a very high cost to be adverse to the wife. Now, he is representing the trust. He is following the terms. He also had some discretion he chose not to exercise in the wife's favor. He had absolute discretion. He could have complied with the trust and exercised his discretion and not fully disinherit her. For example, the Q-tip trust. He had discretion there where he could have let her remain an income beneficiary under the Q-tip qualifying trust. But he chose not to. We can see why. But he has his own significant negative consequence from settling. It's better than going to trial and losing, but settling the legal malpractice insurance policy limits a severe event, probably increasing his LPL insurance premiums, but also is not the best way to advertise your legal services. So what happens with this motion to intervene?
The trustee
Loses at the trial level, and he loses again on appeal under number 1. You have to meet all 3 of these criteria to be able to intervene as a third party. First, the applicant must have a recognized direct interest in the subject matter of the primary litigation, not tangential or collateral. Well, the person who is the lawyer, who is the trustee, the named partner of the one-stop shop, he has a direct interest only as the defendant in Lasiter 2. As a legal malpractice defendant. As a third-party trustee to collect the judgment of Lasiter 1, the trustee of the 2 trusts, he has no direct interest in the legal malpractice. The trustee only has an indirect interest, tangential or collateral. His motion to intervene fails under number 1. Number 2, applicant's interest may be impaired by the disposition. Number 3, applicant's interest is not adequately represented. The trustee didn't want the wife's second law firm to receive $400,000 because that would diminish his ability to recoup the $1.4 million she owes the trust. So he was seeking $1.3 million, and factually, the trustee was already garnishing the wife's other assets to collect that $1.4 million. So for all those reasons, on appeal, the trustee loses the motion to intervene. As a result, Lasiter 2, which is released the same day as Lasiter 1. So the wife loses Lasiter 1. It's confirmed she contested the trust, that she is disinherited from future income from the trust, but also the clawback, that she is ineligible to retain $1.4 million out of that first $3 million. Lasiter 2, the wife prevails, that the trustee's motion to intervene is denied. It grants the wife's motion to release the net proceeds so that her second law firm gets paid and the remainder goes to the wife, and finally grants dismissal of Lasiter 2 with prejudice because it had settled 2 years earlier. Let's wrap up with the wealth protection lessons of Lasiter 1 and Lasiter 2. And we're answering these questions. Can a beneficiary who's already received millions in distributions be forced to return those funds if they later challenge the trust? The concurrence in Lasiter 1 is worried about this because the holding in Lasiter 1 says yes, if at any point in the future a beneficiary challenges the trust and violates the no contest provision, not only are they disinherited from future income, they also, the way it was written in this actual trust, the wife here was deemed to have predeceased the husband. And if that's the case, it's a clawback of whatever has been paid up until that point. If it's been 10 years of payments, that could be beyond the ability of that beneficiary to pay back. 2, is the premarital agreement distinct from the trust challenge, despite trust inclusion of a premarital agreement in full force and effect? The answer to this is split. Yes, the premarital agreement is a separate contract. Nevertheless, because the husband included in his revised trust agreements that a condition of remaining a beneficiary in good standing is that the premarital agreement remained in full force and effect. By challenging the premarital agreement, she challenged that specific provision of the trust, which the trial court and the appellate court held was a trust challenge, which violated the no contest provision, and she was disinherited. So, what constitutes a contest that triggers forfeiture under a no contest clause? Challenging the provision. In most instances, a beneficiary should be able to thread the needle by questioning the interpretation by a trustee, but actually demanding, give me $2 million outright instead of, I disagree with your interpretation of the curveball pilot's license provision. You need to set up what it says. That condition was satisfied. He did have an airman's certificate and it was not invalidated. So you should set up that $2 million trust and pay me the income out of it as written in the trust. So there was a way to thread that needle. That's not what the wife and her lawyers did. They actually contested the terms of the curveball, demanding $2 million outright. And by doing that, trial court and the appellate court specifically held that that was a trust contest. 4, this is Lasiter 2. Can a trustee intervene in a malpractice settlement, hear its own malpractice settlement, to offset, collect on a forfeit judgment on behalf of the trust? And the answer is no. You have to have a direct interest. Even though the trustee as a lawyer was a defendant in the legal malpractice case, as a trustee, the trust and the trustee had no direct interest, only an indirect interest, and that's not enough to support a motion to intervene. So why do Lasiter 1 and Lasiter 2 matter? What are the wealth protection lessons? This 9-year legal saga shows us the life cycle of estate planning, from extensive revision after the high asset husband receives a terminal diagnosis. The remaining 9 months of his life, he spends at least 6 months of it working on his estate plan. We see how things were planned. We're also learning what is a contest and what is not a contest. The interpretation of a provision is different than demanding something other than what was written. There are opportunities to thread that needle. A declaratory judgment action on interpretation, not a demand for money outright when it's supposed to go into trust. The key takeaways: no contest clauses are powerful and enforceable, but they're not inviolate. And we will look at, go to wealthlitigated.com. We have additional episodes where a no contest provision does not prevent challenging certain estate planning shenanigans, so to speak. It's very difficult to prove, but it can be done. And in a few states, there's some state Supreme Court results on that issue. Contest is defined broadly to include any action thwarting the grantor's intent. That's why threading the needle is the strategy. Challenging the interpretation, not challenging the terms, just challenging what it looks like they mean, especially when a term isn't maybe ambiguous. Forfeiture, the return of already distributed assets. And this is a significant risk, which was described in the concurrence of Lasiter 1. Premarital agreements, even though they're separate from the estate planning documents, if it's incorporated into the estate plan, it becomes a condition for that surviving spouse to satisfy. And in that instance, like in Lasiter 1, trying to invalidate the premarital agreement was a contest, was a trust contest, because of the incorporation of the premarital agreement's status. Against legal advice, the surviving spouse here, the widow, she had 3 extensive opinions to not challenge the trust. And she and her lawyers did anyway. The against financial advice, in the briefs and in the trial court opinion and in the appellate court opinion, it's generosity versus greed. That's the theme both courts adopt. But the against financial advice may not have been as impactful to the wife because we aren't aware of her other assets. And then the cost benefit analysis really needs to include net after legal fees. The Lasiter 2 turned out to be a net positive for the wife, but out of $2 million, she keeps less than half because she had significant legal fees for both Lasiter 1 and Lasiter 2. Thank you for joining us. Please stay tuned for a preview of our next episode. What's worse than losing half your retirement in divorce? Losing all of it. In the Di Benedetti case, husband earned $11 million as a Major League Baseball All-Star. But during their 16-year marriage, $3.6 million in community assets vanished without explanation. His secret brokerage accounts wife knew nothing about. His day trading disasters. His weekly cash withdrawals with no paper trail. A sandwich franchisee embezzlement scheme where he forged wife's signature and defrauded investors. When wife finally discovered the truth, forensic accountants couldn't find the missing millions. The result after a 7-day divorce trial? Breach of fiduciary duty, a $2 million equalizing judgment, and a quadro-legal strategy that could strip him of 100% of his major league retirement accounts. Find out what happened on appeal in episode 105, Major League Betrayal, part 1 of 2 in the Major League Quadro series. Don't miss it.
This is Wealth Litigated, where the real courtroom battles we analyze today are your roadmap to stronger asset protection and better wealth outcomes. Follow us on your favorite podcast platform or subscribe on YouTube so you never miss a weekly episode. Questions or cases? Visit wealthlitigated.com/questions. This show is for informational and educational purposes only and does not constitute legal, tax, or financial advice. No attorney-client relationship is formed. Consult a qualified professional for advice specific to your situation and jurisdiction. Wealth Litigated is now adjourned.